of this.
Okay. I'm going to end with a bit of a policy philosophy question for all of you. I'm going to start with your last line of your submission, Professor Boyd, where you said, we should acknowledge a more general but important point. The reasons for individual use, the pursuit of pleasure and relief from pain, are not always dichotomous categorizations, but often overlapping motivations for the consumption of cannabis. Now, I think I've heard all of you say in some fashion, you've questioned the idea of continuing to treat cannabis in a criminal manner whatsoever. And you said C-45 still draws on criminal law, but it should be regulatory for what should be a legal product. I think Professor Boyd, you said cannabis, it doesn't deserve criminal sanction. I've heard the phrase, people who use cannabis should not be treated as criminals. You said it's inconsistent with human rights. Yet C-45 continues to do exactly that. It is a criminal sanction-based approach to cannabis. You can't possess more than 30 grams or you risk up to 5 years in jail. You can't grow more than 4 plants or you risk incarceration. Yeah, a 19-year-old selling to a 17-year-old risks 14 years in prison. So my question is given that we have legalized alcohol, there's no criminal sanctions around the possession or use of alcohol, should we be taking a truly legal approach to cannabis and a purely regulatory one? Is this bill getting it right or wrong in that regard?
I think the bill is getting it largely right. My concern, and what I understand, is that the bill is trying to legalize cannabis use for ordinary Canadians, but it also has a twofold purpose of trying to eliminate organized crime, which, until this point, because cannabis hasn't been legal, has gained a foothold. So the two purposes of the Act are to decriminalize it for the ordinary Canadians and to get the criminals and organized crime out of the production and distribution of marijuana.
But why should I be criminal if I have 40 grams of cannabis? What makes that criminal as opposed to 28 grams?
Well, you know, that's an arbitrary example, but the intent of the Act is to eliminate the influence of organized crime. Okay. And so by trying to achieve both purposes, there's going to be a slight compromise, and that's what concerns me, because some of that flows into criminalizing ordinary possession.
Professor Boyd?
I want the Act to succeed. It's a good piece of legislation. It's headed in the right direction. I see a lot wrong with it. I mean, I see too much criminalization. And I, you know, to go to the point earlier, why are we setting limits? We don't do that with alcohol. I think all of this is going to change over time, but let's first stop criminalizing people for this activity. Recognize that governments have to move slowly to allay the fears of those who are either opposed or concerned about what legislation might bring. And I would really like to see the elimination of Section 8. I really don't understand the criminalization of possession of illicit cannabis. There's going to be a need to control the trade, and I'm hoping we don't have to use police presence to do that. I'm hoping that we can use civil regulatory approach. Ultimately, this will be regulated in much the same way as alcohol. I have no doubt that even when we take rates of use into account, there's no way that this drug is anywhere near as dangerous to public health as either alcohol or tobacco.
Thank you.
That's a great way to finish off. A great question, a great answers. So I just, on behalf